I'm attorney Michael Leline, and I am licensed in Texas and California. And I have a guest today, Jason Fick, kind of like John Wick. Tell you is everything that I'm talking about today is non-commercial. I'm not getting paid for this. I'm not sponsoring anybody. And I want to have this guy come on and talk about Section 230 and what's going on in our country with respect to the internet and social media companies basically censoring families, parents, anyone who doesn't go along with their political viewpoint. And so I want to go ahead and have this gentleman come on. Go ahead and tell us about yourself and about your background.
Thanks, Michael. As you said, my name is Jason Fick. I have I got into the social media world years ago, 2010, in fact, and I built a very large audience on Facebook. At one time, I had almost 38 million fans, and I became very good at advertising and marketing online. Now, I built my business on Facebook because they promised us reach and distribution. We just had to come build it. Well, I did that. I did exactly what they told me I could go do, only to have them take everything from me because they started to compete with me. Now, I spent a lot of years, building building my business and building my distribution network and so forth, only to have it ripped away. And the reason is real simple. They wanted to make more money. Now, in 2016, I caught them. I caught them red-handed, right? What happened in my circumstances, they took down my content, somehow claimed, it violates their community standards, which of course I'm sure, almost everybody has had something, violate the community standards. And of course, those community standards are completely ambiguous. You have no idea what is and is not violations of their rules. And normally they could maybe argue that something I did was wrong. Well, that's not exactly how it played out. What ended up happening is that after about 3 or 4 months of, being deleted, so to speak, and it was about half my audience at the time was gone, they my competitor, who was still a friend of mine, he reached out, and I was talking to him and I said, "Hey, can you see if your reps will get my pages back?" And what I mean by that is that they had spent far more money on advertising with Facebook, and they had specific reps from Facebook that worked directly with their company. They had different access that I had. So they asked Facebook's representatives and said, "Hey, can you get Mr. Fick's content back? Can you reinstate his pages?" And Facebook's response to that was, "No, we're not going to reinstate his content unless you own it," meaning my competitor. So, realizing what was going on here is that Facebook was essentially pushing me out of the reach and distribution market. They were working and conspiring with my competitor to force me out of business. So, what did I do? We transferred the pages to my competitor, and sure enough, 3 days after contract was signed, pages were in their hands. Lo and behold, my content that supposedly violated the rules no longer violated the rules. What that proved was it had absolutely nothing to do with the impropriety of my content. Nothing I said or did really violated the rules. It really had to do with who spent more money. Exactly. So long and the short of it is that we now had them dead to rights. We had the proof. So we sued. And I sued them for anti-competitive misconduct, fraud, extortion, and tortious interference, which are basic torts. And it was evidence.
Question, federal or state court?
I'm sorry, what? Oh, we
Federal
went
or
to
state?
yeah, we went to federal court. We sued in the Northern District of California federal court, and then ultimately ended up in the Ninth Circuit, and we went to the Supreme Court. Now, here's where things get kind of weird, right? Most people think that they would argue that they can do whatever they want, they can take it down. Now, a lot of people, and it was funny because, 2, 3 days ago, you thought to yourself, and you even said to me, well, what they're doing is not in good faith. But the reason isn't what people expect. They think, well, this law, right, which is Title 47 U.S. Code Section 230 of the Communications Decency Act. Most people just know it as 230 or Section 230. It's the law that protects these big tech companies from specifically moderating content, and it prevents them from being treated as someone else for what somebody else does. Now, that law was misread, misapplied. And what ended up happening is this. There's three main sections to this section of the law that protects big tech. The first one is almost entirely overlooked. People have no idea that they actually have to be good Samaritans. Now, what exactly is a good Samaritan? Well, there's two basic principles of a good Samaritan. One, they can either not act, meaning like say you're driving down the highway and an accident occurs, right? Car crashes. You are not obligated to do anything. You don't have to render aid. You can just drive past. May not be the best person, but you don't have an obligation there. And you would be protected from, because you can't be treated as the person who hit or caused that accident, right? Pretty simple. The second thing is you could stop. You could try to render aid, right? In good faith. And the point of that is that say you get out of your car and you run over and you smash their window out. But in smashing their window out, you cut them. Whoops, right? But the idea there is that if you were acting in good faith to save their life, they're not going to be able to come after you for having accidentally cut them, committing an otherwise unlawful act because of what you did. You did it for their own good. Okay. That's what a good Samaritan does. That's the basic principles of it. And that is basically how Section 230 itself works. First, it says the motivation is they have to be a good Samaritan. The second part says, well, if they don't do anything, they can't be treated as someone else. And the third part says, well, if they take any action at all, they need to act in good faith to restrict certain bad content. The purpose of that originally was to protect children from harm. It was to incentivize these companies to have some protections when they acted as a publisher, right?
Quick question. So you're telling me that when they put a label on someone's content, that it says, fact check, this is hate speech, or this is fake, or this is false, that means that they aren't immune from being sued if they try to disparage me and say what I said is fake when you and I both know it's true. That means that they can't escape liability from being sued. Is that true?
In the correct application of the law, Section 230 would not protect them. And the reason being is that they are not being treated as somebody else for what somebody else did. They were involved in, partially they were acting, right? But they were acting what? To discredit, to restrict those materials. But they didn't just restrict the materials, they actually disparaged them. Let me put that in context here, okay? Imagine now for a moment that a car accident happens again, and you pull over, and you, instead of rendering aid, you come in and argue with the driver that it was his fault, that it wasn't somebody else's fault. Now you've turned it into a disparagement of their driving skills are worse than the person who actually caused the accident. They've gotten involved in the whole scenario. Well, that's not treating them as someone else, and that's also not trying to render aid in good faith. That's something totally different, isn't it?
It sounds like they've entangled themselves into the argument by hiring a third-party fact checker, which is probably one of their shell companies or a shell nonprofit or one of their political allies to go ahead and fact check it to try to escape liability by saying they didn't publish it. But in fact, didn't they publish it by putting the fact check label on there that's false?
So there's titles and labels to everything that they do, and they confuse people with these labels, right? And that this the difference between a publisher and a content provider, right? So think of it this way. If somebody publishes something, they just say it's a fact, and then Facebook or Google or whatever, they don't like it and they say it's wrong. So you're right, they do have a relationship. They have some sort of special bond with these fact checkers. Why? They pay them. Now, why do they pay them? They create content, right? I mean, if they're creating a contradicting argument, different information, they're creating information and they're paid to do so. So Facebook is laundering content creation. These labels are important here. If they're paying some other company to create the information, they're just laundering content provision through another entity.